So we have completed Article 23, which talks about the prohibition of traffic in human beings, which we have discussed what exactly is trafficking of human beings and what is forced labor. Let's resort to Article 24, which talks about prohibition of employment of children in factories, etc. For this, we'll go to directly to the article so that it can be very much clearly understood by you guys. This is Article 23, which we are talking about prohibition, which we are talking about prohibition of human traffic in human beings and forced labor, that we have studied. Trafficking in human beings and begar and other similar forms of forced labor are prohibited, and in contravention of this provision shall be an offense punishable in accordance with law. When we are talking about in accordance with law, what we are talking is Indian Penal Code. So Indian Penal Code provides the punishment for forced labor, and nothing in this article shall prevent the state from imposing compulsory service for public purpose, and in imposing such service the state shall not make any discrimination on the grounds only of religion, race, caste or class or any of them. So there cannot be any discrimination that this particular person can be trafficked or it cannot be trafficked. For everyone, irrespective of their religion, caste, color, class or anything, they will be punished. Okay, so now let's move to right to freedom of religion. Article 24 is not being mentioned in this slide, so most probably I will be when we'll be revising, we'll be discussing Article 24. It is nothing but it is talking about forced labor for children. So in any industrial areas or hazardous activities, if there is any involvement of children in that particular hazardous activities, then it is considered to be a crime and the offender will be punished. And it is the right of the children that they should not be exploited to work under the hazardous condition. And any children below the age of 14, if employed in hazardous activity, irrespective of his will, the person who employs such child or children is considered an offender because he violates Article 24. Right? So this is what Article 24, this is the gist of Article 24. I've just tried to explain it to you, but since the slide is not available, I'll reiterate when we will be having that slide. So till now, we'll move forward with the right to freedom of religion. Article 25 provides us the freedom of conscience and free profession, practice and propagation of religion. So first is free conscience. We can choose which religion we want to. We can choose whether we want to be a Hindu, whether we want to be a Muslim, whether we want to be a Christian, whether we want to be a Sikh, Jain, Buddhist, etc. So any religion which our conscience, our mind feel and wants to practice, then we can profess that particular religion, we can practice the norms of that particular religion, and we can propagate that particular religion. Okay, free profession and freedom of conscience and free profession, practice of that particular religion and propagate the religion. So there are three things that we need to consider. First is the profession, means the incorporation, profession of that article, of that religion. So of that religion. Okay, so me being a Hindu, somebody being a Muslim, another being a Christian. Why is it so that everybody has this say that I want to be a Hindu, I want to be a Muslim, and another want to be a Christian? Because we have Article 25, which is giving us right that we can profess any religion, then we can practice the norms of that particular religion. When we talk about going to the mosque and reading the Quran and doing our prayers, there is a certain practice that we follow. Okay, that is the practice. When we talk about Hindus, there is a ritual of worshipping the idol. Okay, idol worship is there. What is that? That is a practice. So all these practice, who is giving us the right? It is Article 25 of the Constitution, which is providing us with the right to practice, profess, and propagate. Propagation means to spread the religion. You must have seen at various instances that there are people who are explaining that these are the benefits of reading this novel. This is the benefit of reading the Quran. This is the benefit of reading Bhagavad Gita. So all these are what? These are propagation of the religion, so that if somebody wants to adopt that particular religion, they can adopt it. Okay. So there are, but again, when we talk about Article 25, it is not like that these rights are absolute. Okay. These rights are not absolute. We cannot do something in the name of profession, practice, and propagation of the religion, that we start using loudspeakers late night at 12 o'clock and 1 o'clock with chants of worshippings. That is something which will be against the public order. So, when we talk about Article 25, there are certain restrictions, and that is, first is public order, second is morality, and third is health. And other provisions of the part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate any religion. So these are the three things which are an exceptions. That first being public order, second being morality, and third being health. So public order, you understand? Public order is something which means the order given by the government for the benefit of the citizens. So if there is any public order means no use, example, no use of loudspeaker post 10 o'clock, 10 p.m. This is a norm, because it will obviously cause noise pollution. Then if you are propagating and you are saying that I have a fundamental right to propagate my religion, to practice my and profess my religion, and for that I am using loudspeakers, then the officials would say that it is subject to public order, and that is why you cannot profess, and you cannot say that you're utilizing your fundamental rights, and that is why you cannot practice post 10 o'clock the use of loudspeaker, in just to say that you are practicing or professing your fundamental right to religion, because it is an exception of public order, morality, and health. Morality means moral well-being. Somebody says the sacrifice of someone in order to praise, in order to worship any lord, is something which is considered immoral, and for that sacrifice is considered to be an immoral activity. You must have heard the sati pratha, that people, what they used to do was that they used to ask the widow to sit along with the dead body of the husband, and then it was when the flames was higher, the widow used to burn alive, and that was considered to be a very immoral act, which was against the morality and also was against the health of the widow. So taking that thing into consideration, freedom of profession, practice, and propagation of religion has certain limitations, that is public order, morality, and health. And if at all these things are taken into consideration, then only apart from these three, there is no limitation to practice, profess, and propagate your religion. That is what is Article 25 subclause 1 is providing. What is subclause 2 saying? Nothing in this article shall affect the operation of any existing law or prevent the state from making any law. Okay, so the state, that is the state government and the central government, both have the authority to make laws in regards to the religious activities if at all, if it cannot be said that since we have the right to profess, practice, and propagate a religion, the government will have no say in that. They can also make the laws. In what sense they can make the laws? In regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practices. Okay, so if you want to organize a Kumbh Mela, might have heard. So the state government made sure that what will be the limitations, till what time the persons will be allowed, till what time the devotees can be present there, how the whole transaction will take place. Everything will be decided by the state government. So it is saying that it will not prohibit the state government from making the laws, and it will not be said that the state government is interfering in the fundamental right of the citizens. Okay, by virtue of art subclause 2, it is giving the state the authority to make laws even in matters of religious practices if it is in relation to economic, financial, political, or secular activities. Providing for a social welfare and reform, or the throwing open of Hindu religious institution of a public character to all classes and sections of the Hindus. Okay, so for that also the government can make laws. The varying, and this is an explanation that you need to understand, but obviously this is not something very important, so I won't be dealing into it. But you need to understand that wearing and carrying of kirpan shall be deemed to be included in the profession of six religions. Okay, so whenever they are carrying kirpans and wearing kirpans, then it shall not be understood that it is something which the person cannot do, because it is deemed to be inclusion in the profession of six. In the subclause 2, subclause in explanation 2 in subclause B of clause 2, the reference to Hindus shall be constructed to include Sikh, Jain, Buddhist religion. Okay, so when we talk about Hindus, it includes Sikh, Jain, and Buddhism. This is something that you need to remember, and it is an important portion when you talk about freedom to religion. Then it is freedom to manage religious affairs. That is same under Article 26. That is not very important. But it only talks about maintenance of the institution for religious activities and charitable purpose, and own affairs, to manage the own affairs when, for instance, the Waqf board decide when Eid will take place. When Eid will take place, the Pandits decides when the holy calendar starts. So there are various activities which will be managed by the institutions only of that particular religion, but it is also subjected to three things, that is public order, morality, and health. So you need to remember that when you talk about freedom of religion, so freedom of religion is subjected to three exceptions. First is public order, second is morality, and the third being health. So this is first, this is second, this is third. These are the 13 exceptions that you need to understand. And when you talk about manage affairs, it also talks, and perhaps it is an important article, that to own and acquire movable and immovable property and to administer such property in accordance with the law. So from this particular article, you find mention that even an idol under Hindus can possess movable, immovable property. For example, Lord Krishna can have any movable property in his name, or immovable property in his name, and that administration of such property shall be accordance with the law. So when we talk about accordance with the law, it means a trust that will be created in the name of Lord Krishna, who will be managed by some entities, and these entities will be obviously human beings, and these human beings will decide how the property needs to be managed, and by detailed discussion it will be named under the name of Lord Krishna. The property will be in the name Krishna, but it will be managed by this trust that will be managed by these particular people. So this is what is the advantage of acquiring property in the name of the prophet, because all these properties are tax free. These are tax free properties. For that we will have to dig uh, deep into that income tax section, everything, which I won't be going forward with. But for you, it is important to understand that even an idol can have a immovable property by virtue of section Article 26 subclause C and Article subclause D. Now, I just informed you about taxes. Freedom as to payment of taxes for promotion of any particular religion. No person shall be compelled to pay any taxes than the proceeds. This is Article 27. I have just informed you, and I don't feel the need of explaining these things. All you need to understand, it's perhaps not very important for you, not very important. The only thing you need to remember is that there is a freedom of payment of taxes, exemption to payment of taxes when we are talking about uh, propagation propagation practice or profess any religion. But what you need to remember, that there is an exception, and that exception is talking about public order, morality and health. Yes, that is clear. Now, this is the last article which talking about freedom of religion, and that is 28, attendance at religious instructions or religious worship in certain educational institution. No religious instruction shall be provided in any educational institution wholly maintained out of state funds. Since state, when we talk about state, we talk about Article 12, and when we talk about Article 12, anything which is being maintained either by the parliament, either by the legislatives, either by the local authorities or by the other authorities, if they be managed by that funds, then there will be no religious instructions that will be provided to them. But if there is any institution which is maintained partially by state fund and or by the religious institutions, there you can find mention of religious instructions. So you will get religious instructions if you are talking about Article 28, if you're talking about institutions which is being managed partially by the state funds or wholly by the religious institutions. There you can find the religious instructions may be provided. But any education institution where which it is wholly be maintained by the state funds, there you will not find mention of any religious instruction. That is what has been mentioned under Article 28. Nothing in this clause 1 shall apply to any educational institution which is administered by the state but has been established under endowment or trust which requires that religious instruction shall be imparted in such institutions. So that is what I have explained it to you under this particular portion, that if it has been partially maintained or by instituted by the religious institution, then there you can provide information. This is not important for you, we will not be moving forward. And then cultural and educational right, Article 29 and 30, talking about protection of interest of minorities. It is talking about reserve categories, where which we are talking about backward classes, any sections of the Indian citizens residing in the territory of India or any part thereof having a distinct language, script, important, distinct language, script, culture of its own shall have the right to conserve the same. Okay, so if somebody is coming from a distinct place which they have a different language, and since India is a secular country, so we respect all religions. And if you're talking about different languages coming from, and we don't have inequality, so India being a diverse country, we respect every religion, every culture, and every person, irrespective of caste, color, creed, place of birth, etc. So, taking into consideration that thing, any person who has in minority also will have the same interest as those in majority. So, which means that every person who is in minority will be also given the same type of interest. Then why is it so that we have maintained a separate article? The reason being, in order to make sure that these particular minorities are also given certain rights and there is no confusion, it was perhaps important to give a separate article which provides special relief to all the backward classes. So any sections of the citizens residing in the territory of India or any part thereof shall have a distinct language, script, or culture of its own, shall have the right to conserve the same. So they have the right to conserve the same. Okay, same. It is something which is obviously will be taken into consideration in resonation with Article 25, which is talking about the right to religion. In the same way, if somebody have the right to religion but have a distinct culture, has a different culture, and they want to maintain that, so they have the right under Article 29. And no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of the state funds on the ground only of religion, race, caste, language, or any of them. So this is an important article which provides that every citizen shall be admitted into an educational institution if it is being managed by the state funds partially or fully, or it is receiving state funds, then only on the grounds of religion, race, caste, language, or any of them, they cannot be denied admission. What does that mean? It means that if it is only on the ground of religion, race, caste, language, or any of them, then they will not be provided admission. But if along with the religion there is some other criteria also, meaning which they are not able to qualify that examination, they are not having that skill set that is required to be taken admission in that particular organization, then they can be denied admission. So students often get confused that when we are saying denied admission, that the person belonging to Hindu category was not able to qualify the examination and a person belonging to other category was given admission, then sir, how come is it possible? I have often encountered these type of questions whenever I am teaching the students. So for your better understanding, I'm just explaining it to you again. If at all, only on the basis of religion, race, caste, language, or any of them, if any citizen, no citizen is mentioned, no citizen shall, it means every citizen be denied, be admitted into any educational institution maintained by the state or receiving out the state funds, and there will be no discrimination only on the basis of religion, race, caste, language, or any of them. But if religion combined with qualification on this particular basis, the citizen can be denied admission. So that is what you need to understand. This is not important for you guys, so we are not moving forward. The state shall not, in granting aid to the educational institution, discriminate and against any educational institution that it is under the management of minority, whether based on religion or language. So it is the duty of the state that has been omitted. When you talk about Article 31, what was it talking about? It was talking about right to property. Okay, right to property it was talking about. It was earlier under Article 31. Then by the 44th Amendment 1978 it has been omitted, and it now has find its mention under Article 300A, which is a constitutional right. We have already studied it in detail in our previous video. If you want to observe it, you can see through it, but here it is just for your revision, that Article 31, which was talking about right to property, has been removed, repealed, omitted by 44th Amendment 1978 with effect from this particular date, and certain times this date has also been asked. So you need to remember 26 June 1979. So since 20 June 1979, your right to property has been converted into constitutional right rather than fundamental right. What exactly is the reason? I have already discussed, so we are not going forward with that. Saving of saving of certain laws. This is 31, which is not this obviously not going to be asked to you, so we are not going to study that particular thing. And I suppose this is majority of the things are validation of certain acts and regulation. This is not, which is very important for your CLAT examination point of view, so we are not going into that. Saving of laws in respect of this is omitted. We are not going to study that. Now this becomes an important topic which is going to be studied, which is Article 32. I have already started discussing it in our previous lectures, and let's understand what Article 32 is talking about. And when we talk about Article 32, the first and the foremost thing that we need to understand is it is talking about right to constitutional remedies. So when we talk about remedy, so obviously remedy will only be done if there is any infringement, right? So if you talk about infringement of what? So infringement of fundamental rights. So whenever there is an infringement of fundamental rights, you have the right of constitutional remedies. The remedies which has been provided by Constitution. If your fundamental rights is being violated, and this power has been given to the Supreme Court. This is the gist of what Article 32 is, and the power that has been provided to the Supreme Court is again through writ jurisdiction that you find under Article 32, and there are 5 type of writs which is given to the Supreme Court, which they will utilize in order to make sure that the fundamental rights of the citizens who have been infringed can be restored. So this is the main crux of Article 32. Let's try to analyze and understand what exactly is Article 32 talking about. So Article 32, when we talk about Article 32, it is remedies for enforcement of rights conferred by this part. Okay, when this part, which part? It is talking about part 3. What rights? We are talking about rights which is fundamental rights. And fundamental rights, what we are talking about? We are talking about Article 14 to Article 30. Yes, because 31 is already omitted, and 31 A, B, C and D are talking about certain saving clauses, where which it has been mentioned. Obviously we are not going to deal into it, but for you guys you need to remember all the articles, fundamental right that has been provided from Article 14 to 30. If at all there is any encroachment of these fundamental rights, then the remedies for that encroachment has been provided under Article 32. What does that article says? The right to move the Supreme Court by appropriate proceedings. Appropriate proceedings means by filing an application. For the enforcement of the rights conferred by this part is guaranteed. Is guaranteed means it is compulsory. It is compulsory. Whenever there is infringement of the fundamental rights, it is guaranteed that you will be given remedy by virtue of Article 32 by the Supreme Court. And this is how the fundamental rights are considered to be enforceable. fundamental rights are considered to be enforceable because it is a guaranteed part which is being provided by the Supreme Court. If at all there is any encroachment, then remedies be provided by the Supreme Court in form of writ jurisdiction, and all your fundamental rights whichsoever has been encroached will be restored. Proceedings for the enforcement of the rights conferred by this part is guaranteed. The Supreme Court shall have the power to issue directions or orders. Directions to the officials, or orders or writs. So these are three things that the court can give. First is direction, second is order, third is writs. Now when we talk about directions is telling the authorities what needs to be done. Okay, just directing them. Orders, based on the merit, order be passed. Okay. For example, there was the case of Ram Mandir. Yes. So in the Ram Mandir case, it was not a writ that was passed by the Supreme Court, but there was an order that was passed. So it shows that the Supreme Court not only provide writs as a remedy, but it also provide directions, orders, and also the writs. But for your understanding, we need to only study writs, which will be asked in your CLAT examination. And those writs are first being, the first writ is habeas corpus. This is habeas corpus, which means to have a body. If somebody is illegally detained, you use the writ of habeas corpus to produce that person into the court, and then the court will decide whether that person has been illegally detained or his fundamental right has not been infringed. Then you have mandamus. Mandamus means we command. Okay, we command means the court commands that if somebody's fundamental rights has been infringed, you restore his fundamental right. The third one is prohibition. Prohibition means if the Supreme Court feels that there is any sort of court proceeding that is going to take place in a court inferior to the Supreme Court, whether it be a high court or the subordinate court, and by that particular proceeding, somebody's fundamental right is going to be infringed. So they prohibit that particular court to take that particular proceeding forward, and they directly ask that particular court to send the files to the Supreme Court so that they can see that whether that particular proceeding is going to infringe somebody's fundamental right or not. Okay, for the passing of this degree, for passing this particular writ, first you need to file an application that this particular court is going to pass a proceeding which a particular person's fundamental right will be infringed, and that is why we request the Honorable Court to provide a writ of prohibition to stop that court from proceeding forward, and you please take the case suo motu by yourself. Then another case is certiorari. Certiorari means that if there is any judgment that has been passed by the inferior court and which is going to take away or infringe the fundamental right for any citizen, then you can directly move to the Supreme Court and you can tell that this particular court has passed such judgment which is going to infringe the fundamental right of this particular person. If the court is satisfied, then the court will pass the writ jurisdiction of certiorari, quashing the judgment of the inferior court, and through that particular judgment, quashing the judgment, and through that the Supreme Court will take up the matter and see through it that whether that particular matter is correct or not, and will try to restore the fundamental right of that particular citizen. And the last one is quo warranto. Quo warranto means by what authority? By what authority? Certain time it has been seen that the person who has been on a particular post, they don't have the qualifications, they don't have the right to be at that particular post, but by the abuse of their powers, they sit over that particular post, and certain times they pass any orders or directions which is beyond their post, beyond their jurisdiction. So for that, by passing the degree of quo warranto, by passing the writ of quo warranto, the Supreme Court asks that by what authority you have passed such orders or degree or judgments or directions. And if you are not, if the if that so if the Supreme Court is not satisfied by that what authority that particular person has passed that particular order, then that order will be quashed. So these are the five writs which the Supreme Court has the jurisdiction and the authority to pass. And by passing these five writs, the Supreme Court can restore and we can provide a remedy for the enforcement of the rights conferred by the Part 1 for all the citizens whomsoever are there. It doesn't mean that the Supreme Court only pass these writs. It is the High Court who can also pass the writs under Article 226. But whenever there is a question that who has much wider scope in comparison to the passing of the writ jurisdiction, so please remember this particular point in mind, that it is not the Supreme Court who has a vast power, but rather it is the High Court who has majority of the power that has been provided to them. I suppose you have understood what is Article 32 talking about, and it is the Parliament who can empower any other court to exercise within the local limits of its jurisdiction all or any of the power exercised by the Supreme Court under Clause 2. That is, that to pass the writ. And by this particular judgment, by this particular thing, Parliament has given the power to the High Court to pass this particular writs. The right guaranteed by this article shall not suspended except as otherwise provided for or by the Constitution. It cannot be suspended until unless there has been otherwise provided by this Constitution. So only by this Constitution this can be suspended. And since now this has been kept under the basic structure, it has been kept under the basic structure, Article 32, the writ jurisdiction, right to constitutional remedies. So it cannot be suspended. So if now you have understood, you will be able to understand that how the Constitution has been drafted in such a beautiful manner that anybody's fundamental right, if at all it has been taken away or confiscated, you have the right to resort to the Supreme Court, and the Supreme Court, by the issuance of by virtue of Article 32, can pass the different writs which will help in restoring of your fundamental rights. Moving forward, all the things apart from Article 32, we don't have to study Article 33. And with that, we come to the end of our video. And from the next class onwards, what we are going to study is, we are going to study the executives and the judiciary. First, we will complete the executive. That will only take us one lecture in which we will be understanding what exactly is a parliament, what exactly are the powers of the president. These are the questions that will be asked to you. And then we will be moving forward with the Supreme Court, that how is the Supreme Court constituted, what are the jurisdiction of the Supreme Court, and what are the different powers and authority that has been provided to the Supreme Court. Once you are well versed with the Supreme Court and the executive, the central executive, then it is just again it will be sort of a revision for you when we will be understanding the high courts and the subordinate courts and the state legislatures. Because when we talk about the executives, what we are talking about the central executives. Okay, and when we started with the Constitution, we remembered that we have already studied that India is a federal structure, meaning which it has division of powers at the central level and the state level also. So once you have studied the central level, it will be very much easier for you to understand what exactly is going to happen at the state level, because almost everything is similar. There are certain exceptions when we talk about the state legislatures and the central legislatures, but majority, 80% of the things are the same. In the same way the parliament have the powers to make the laws, the same way the state government also have the power to make the laws. In certain areas you will find um, when you compare the parliament with the state legislative assemblies, the state government, you will see that at the central level you have the Lok Sabha and the Rajya Sabha. In the same way, at the state level you have the uh, Vidhan Sabha and the Vidhan Parishad. But at certain places, because of less number of crowd and citizens residing in that particular country, Vidhan Parishad is often being removed because there is no point, and it will obviously take a lot of work, and it will overpower, and it will destroy. It will not be important for creation of that Vidhan Parishad. So that is why there are only certain state where which you will find Vidhan Sabha and Vidhan Parishad, but majority of the places you will only find Vidhan Sabha only, that is legislative assembly, which is all. If we compare it with the center, it can be equivalent to Lok Sabha, that is the house of the people. So this is what we are going to study in our upcoming lectures. We are going to study the executive, the judiciary, and post completion of executive and judiciary, we will move forward with uh, the emergency provision and the amendment provisions of the constitutions. And after the completion of the amendment provisions and the emergency provisions, we will move towards the election commission, and after that we will just quickly revise what are the important articles of this constitutions are, and how to recall every part of the constitution. And after completing all these things, our constitution will be completed, and then we will be moving forward with the international laws, the family laws, and any other little maxim that is required to be completed for a preparation of your CLAT examination. With this, I would thank you all to be for your presence in this particular lecture. I hope this lecture was helpful for you, and we hope that uh, um, particular exam that is going to be scheduled of CLAT examination, these lectures are going to be very much helpful, and you are able to comply with the three principles which I've informed. That please uh, remember the principles, practice consistently, and be persistent. With this, thank you so much everyone for being present in this video. I will meet you in the next video.